My respected and valued viewers, today I'm very much pleased to talk to you by this video on the topic of criminal law, which is useful to all. And the topic is beyond reasonable doubt versus preponderance of probabilities that is applicable to the accused. It means the prosecution must prove its case against an accused beyond reasonable doubt by a sufficiency of credible evidence. Now, two questions arises. As per Section 101 of the Evidence Act, prosecution has to prove the case beyond reasonable doubt. Now, question is, what is meant by reasonable doubt? Beyond reasonable doubt. Now, second question for defense arises, what is meant for preponderance of probabilities? I will explain both the terminologies and details. Now I'll take the first question related to the prosecution. A person has no doubt a profound right not to be convicted of an offense which is not established by the evidential standard of proof beyond reasonable doubt. Now what is the meaning of reasonable doubt? Time and again, our London Supreme Court has explained the interpretation of this terminology, legal terminology, a reasonable doubt. A reasonable doubt is not an imaginary, trivial, or merely possible doubt, but a fair doubt based upon reason and common sense. It must grow out of the evidence in the case before the court. Now the next question, what is meant by preponderance of probabilities? This is very important. Now for defense, two criminal procedure sections are applied. One is section 313, that is the examination of the accused at the end of the trial. And second is 315. If accused is 100% innocent, then after examination under section 313, he has to submit an application seeking permission to appear as a defense witness in the witness box from the magistrate, London magistrate. And he can give testimony in oath under section 315 of CRPC. Now, if you look at the Indian Evidence Act, then two sections are applicable to the defense. That is section 103 and section 106. These two sections are applicable to the defense if he knows some particular fact which is not known to the prosecution. It is well established that accused has only to create doubt about the prosecution case and probability of his defense, and not required to establish or prove his defense beyond all reasonable doubt. The law is quite well settled that the burden of proving the guilt of the accused is on the prosecution. But there may be certain facts pertaining to a crime that can be known only to the accused or are virtually impossible for the prosecution to prove. These facts need to be explained by the accused, and if it does not do so, then it is a strong circumstance pointing to his guilt based on the facts. Now CRPC 313, it has got special significance because at the end of the trial, accused is examined by the London magistrate. He has to give explanation whatever evidence is against him during trial. For that, a defense may not have been taken by the accused under section 313 of CRPC. Again, cannot absolve prosecution from proving its case beyond all reasonable doubt. Prosecution is unable to answer weakness in defense taken cannot become strength of prosecution to claim that In the circumstances, it was not required to prove anything. It means prosecution has to stand on its own legs. It cannot exploit the weaknesses in defense. Now, all press into service Evidence Act Section 106. Section 106 Evidence Act is not intended to relieve prosecution of its burden to prove guilt of accused beyond reasonable doubt. But it is conditional. But section would apply to case where prosecution has succeeded in proving facts for which a reasonable inference can be drawn regarding existence of certain other facts, unless accused by virtue of special knowledge regarding such facts fail to offer any explanation which might drive court to do a different inference. Of course, there are certain exceptions to the said rule, where burden of proof may be imposed upon the accused by reason of statute. For example, in check bouncing case, under Section 138, the burden of proving innocence of the accused is on accused. It is well established that taking no defense under Section 313 of CRPC 1973 does not absolve prosecution for proving its case beyond reasonable doubt. I have repeated again. Burden of proving a plea specifically set up by an accused lies upon him, but neither the Section 103 nor Section 106 of Evidence Act can absolve prosecution from discharging its general or primary burden of proving its case beyond all reasonable doubt. Besides, silence of accused alone will not rebut presumption of his innocence when prosecution failed to prove his guilt. Our Indian Constitution also has given a special right to accuse. Right under Article 20 in bracket 3 of our Constitution includes right to remain silent. The accused has to remain silent during trial. Burden of accused. Evidence Act Section 106. Now it reads, facts within special knowledge of accused, not explained by him, will be a strong circumstance pointing to his guilt. Now I'll give two examples, two illustrations on the basis of Indian Evidence Act. First example, illustration, he is charged with traveling on a railway without ticket. The burden of proving that he had a ticket is on him. This section 106 of Evidence Act provides inter alia that when an fact is especially within the knowledge of any person, the burden of proving that fact is upon him. Now, Mr. E is traveling in a train. TC comes to him and asks him to show his ticket, but if he fails to show it, then TC will tell him that I will penalize you, or if you are not being penalized, then I will take you to the police for legal action. At that time, for proving that he is traveling with ticket, he is upon accused, because it is special knowledge confined to the accused. So this is the illustration. Another second illustration is very, very important. This is given in Ganesh Lal versus State of Maharashtra, 1992, 3 SCC 106. In this case, the appellant was prosecuted for the murder of his wife inside his house. Since the death had occurred in his custody, it was held that the appellant was under an obligation to give an explanation for the cause of death in his statement under Section 313 of CRPC. No escape route. He has to give explanation. A denial of the prosecution case, coupled with absence of any explanation, was held to be inconsistent with the innocence of the accused, but consistent with the hypothesis that the appellant was a prime accused in the commission of murder of his wife. Now, it is very clear when burden of proof comes on accused and when burden of proof comes on prosecution. Hope you enjoyed this video. Please remember, law is power. Use it, but Don't miss it. Thank you so much for watching this video. Really, I thank you from bottom of my heart. See you in the next video. Share it, enjoy it.